A lot of people have heard of Marbury versus Madison. You may remember hearing about it in school and that it was important. But what exactly was it? Why did this Supreme Court case become so influential? How did it reshape the balance of power in the United States? And why is it still a source of controversy today? Why Marbury versus Madison matters. The court case that shaped America. Welcome to Into the Desert, exploring the wilderness of ideas. Don't forget to hit those like and subscribe buttons. We need your support. The algorithms are pushing divisive content while hiding serious discussion. Please become a fellow adventurer on Patreon and support this channel's mission of encouraging discussion, not division. The link is in the description. The first major test of the new Constitution was the 1800 presidential election between John Adams and Thomas Jefferson. When Washington stepped down after serving only 2 terms 4 years earlier, Adams, then the vice president, won. Since Washington was leaving office voluntarily, there was no issue with the transfer of power. The election of 1800 posed a different concern. Adams and Jefferson ran again, Adams as part of the new Federalist Party, and Jefferson, a Republican, what we now call the Democratic-Republican Party, to distinguish it from the current Republican Party. They were bitter opponents. Unlike the previous election, Jefferson won this time. However, in one of the more difficult elections in U.S. history, he tied with Aaron Burr. The election was thrown into the House, which eventually picked Jefferson. While British parliaments had been changing hands for well over a century, this was something new, the peaceful transfer of power for a head of state. Not only would the head of state be replaced, but would be replaced by a bitter political opponent. That this transfer followed a messy election is even more astounding. But Adams stepped down, and Jefferson became president. The constitutional system was tested, and it worked. Still, that the power was peacefully transferred did not mean it was happily transferred. The outgoing Federalist Party tried to hamper the incoming Democratic-Republicans. One outcome of this was William Marbury and others nominated and confirmed as justices of the peace in the District of Columbia never received their actual commissions. They sued in the Supreme Court, asking the court to order Secretary of State James Madison to deliver the commissions. This type of order is called a writ of mandamus, and Congress had specifically given the court this power in the Judiciary Act of 1789. The court ruled that the commission's delivery was merely a formality and that its absence did not invalidate the appointment. The court also ruled that Marbury was entitled to a legal remedy. That is, the court should order their commissions to be delivered. These would indicate the ruling in Marbury's favor. All that was left was to issue the writ of mandamus. Still, despite all this, the court said they could not issue the writ, and so Marbury never got his commission. This is not what puts Marbury versus Madison in the textbooks. It is the court's reasoning behind their decision. In considering whether the court could grant the writ, Chief Justice Marshall wrote,
"The powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten, the Constitution is written. To what purpose are powers limited, and to what purpose is that limitation committed to writing? If these limits may, at any time, be passed by those intended to be restrained. The distinction between a government with limited and unlimited powers is abolished, if those limits do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by an ordinary act. Between these alternatives, there is no middle ground. The Constitution is either a superior, paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts, is alterable when the legislature shall please to alter.
The Constitution lists the cases the Supreme Court hears. Basically, appeals, along with cases involving 2 or more states, ambassadors, and such. Marbury's case was not an appeal, and it was not one of the types listed. Still, the Judiciary Act of 1789 gave the Supreme Court the power to hear cases. Yet the court held the act invalid. The Congress could not give the Supreme Court powers not given by the Constitution. As Marshall wrote, the law is unconstitutional and therefore absolutely incapable of conferring the authority and assigning the duties which its words purport to confer and assign. Some critics of the ruling thought Marshall should have stopped there, yet he went on to write,
"It is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If 2 laws conflict with each other, the courts must decide on the operation of each."
In his ruling, some falsely believed that Marshall created the concept of judicial review. That is, the ability to rule a law unconstitutional. Yet, Hamilton argued for that role in Federalist number 78.
The complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority. Such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void.
Marshall's opinion did not create the concept of judicial review. It only made it explicit and a duty of the judicial department. Still, since the Constitution does not explicitly give the Supreme Court this role, it comes from the ruling in Marbury. It is a soft power, a power based on convention and tradition. As such, they exist unless pushed too far. The courts can claim this, but the Constitution does not say the Congress or the executive branch has to agree. Thus, it is probably no surprise that early on, the court was reluctant to push this power too much. In fact, the court did not rule another law unconstitutional for another 54 years. That, unfortunately, was the infamous Dred Scott decision. From 1864 to the end of the century, another 20 laws would be declared unconstitutional. The numbers remained low until the 1930s and FDR's New Deal, but have significantly increased since the 1960s. Marbury also highlights an important distinction often overlooked in the coverage of the courts today. There is a difference between the ruling and the reasoning, between what they ruled and why they ruled. For the participants in a lawsuit, the what is clearly the most important. Did they win or lose? But for the Constitution and the country, the why is far more important. Nowhere is this clearer than in Marbury versus Madison. So what do you think? Did Marbury versus Madison strengthen the Constitution by establishing judicial review? Or did it give the Supreme Court too much unchecked authority? And when the court interprets the Constitution today, should its reasoning matter more than the actual ruling itself? Share your perspective in the comments below. We do read your comments and respond to many. And if you've made it this far, consider watching one of our other videos and supporting our channel out on Patreon. Thank you for watching Into the Desert, exploring the wilderness of ideas. And to our fellow adventurers, a special thank you for helping to support this channel out on Patreon.